Good evening to all of you. Welcome to Legal Matters by Sai Babu Sunkara, video number 1460. This video is intended for the law taught students. Friends, in the morning we discussed the topic of vicarious liability as principal and agent. Now we are going to discuss the topic of vicarious liability with respect to master and servant. Who is a master and who is a servant? Master is so in this connection you have to learn the legal maxim first. Respondent superior, that means let the master be held liable. Respondent superior, who is a master? Master is a person who has got the deep pockets, baga double honor, and who entrusts or who can employ the servants. Who is a servant? Servant is a person who acts as per the instructions or as per the directions of the master. So when the servant does the act, when the servant does the so-called tort, doing the discharge of a duty as servant, definitely master is also liable. This liability is also joint and several. So definitely when your servant does some tort, you will be held responsible, right? Simple case I will tell you. Normally this thing happen. Master-servant relationship. So Rajasthan State Road Transport Corporation versus V.N. Kothari, 1997. Normally we may be knowing, since our buses are not enough, the RTC they will hire particular buses and the driver will be from the owner, whereas the conductor belongs to RTC. Here also same thing happened. APS RTC మనకు కూడా అదే పరిస్థితి. కొన్ని సర్వీసెస్ ఆర్టీసీ దగ్గర డబ్బు లేక బస్సులు కొనలేక ప్రైవేట్ వాళ్ళకి ఇచ్చేస్తుంటారు, రూట్ వాళ్ళకి ఇస్తారు. ప్రైవేట్ వాళ్ళు డ్రైవర్ని పెట్టుకోవడం వరకే బాధ్యత, కానీ కండక్టర్ మాత్రం ఆర్టీసీ వాడు ఉంటాడు. ఎంటైర్ థింగ్ మేనేజ్డ్ బై ఆర్టీసీ పీపుల్ ఓన్లీ. లైక్ వైజ్ రాజస్థాన్లో కూడా ఇది జరిగింది. ది ఐఎస్ఆర్టీసీ, రాజస్థాన్ State Road Transport Corporation, they hired a bus and the driver was running the bus. And of course, RTC, they have employed the conductor who manages the bus and who has collected fare from the passengers and also exercised control over the driver. So RTC కాబట్టి yes, ఈ కండక్టర్ మీద బాధ్యత అంతా పడింది. So incidentally there was an accident. Accident is one which we do not expect, మనం అనుకోలేం కదా. సో యాక్సిడెంట్ అయిన తర్వాత సో హియర్ చాలామంది ఆర్టీసీ, వెదర్ ఆర్టీసీ లైబుల్ ఆర్ నాట్, ఇక్కడ టార్ట్కి అంటే టార్ట్ ఆఫ్ నెగ్లిజెన్స్ అంటారు. ఇక్కడ ఈ నెగ్లిజెన్స్కి ఎవరిది బాధ్యత అంటే సహజంగా ఏమంటారు, ఆర్టీసీ అన్నాడు, ఆర్టీసీ మాకేం సంబంధం, ద బస్ బిలాంగ్స్ టు ఓనర్, సో డ్రైవర్ ఈజ్ హిస్ పర్సన్, టేక్, సో హీ ఈజ్ రెస్పాన్సిబుల్ అంటే కోర్ట్ హెల్డ్ దట్ నో, యాజ్ ఆర్టీసీ. చూడండి ఇక్కడ ఆర్టీసీ ఈజ్ the hirer and it is vicariously liable, notwithstanding the fact that the driver is continued to be on the payroll of the original owner, but this is what is called quasi corporation. The control is by RTC. The owner's responsibility is to purchase the bus and hand over the bus along with the driver to the RTC. That's all. Now RTC is the master and the driver is the servant. They have to pay compensation. Very good case. Sometimes due to the acts of the servants, normally you may not be liable also at times. So suppose let us go to the positive cases. Master servant relationship. Very good case. Cassidy versus Ministry of Health. Cassidy, this happened in London. Cassidy versus Ministry of Health, 1951. So actually here one of the doctors of the so-called Ministry of Health, that is British government, actually they have treated our patient by name Cassidy. Actually her hand has to be operated, but during the operation, that is the two after, that is a post-operative treatment, After the operation, they have not, actually the physiotherapy was not done perfectly, as a result of which some of the fingers they have become useless. After the post-operation care, that should also be careful. It is also the actually responsibility of the hospital staff. Now, since the hospital has employed those people, so the doctor and others, when Cassidy filed a case of tort, of breach of duty of care or professional negligence, then the hospital was held liable. I take. So here they wanted to throw the blame on the the patient. So to some extent they want to throw the blame on the patient because he did not come to the hospital on the particular days as they advised by the doctor. But that's a different part. But clear remember, even though the doctor is a skilled worker, he has to exercise with due diligence. So hospital authority, they have a duty under the National Health Service Act 1946. This is in London, please remember. It is not our act. They have to provide the treatment to the patient. There is a lapse on the part of the surgeon. Therefore, the hospital, the management. So this is Ministry of Health. Now this is the government hospital. They have to pay compensation. This is the master-servant relation, right? And sometimes there may be negative examples also. Hiller versus Saint Bartholomew Hospital. Hiller versus Saint Bartholomew Hospital, 1909. So here, actually, there was a failure in the operation. The patient, that is Hiller, he has filed a case of negligence against the radiographers of the hospital and also the resident house surgeons. So, and a part of nurses, since they have not treated him properly, his so-called his ailment was not properly done. So, it is professional care and skill. Right? The doctors of St. Bartholomew's Hospital could establish that they have exhibited the diligence, care and skill. But alas, every case may not be a successful one. So therefore, it is negated. The hospital authorities, the doctors are not responsible. Now we'll go to the master and independent contractor. I already told you who is an independent contractor. Independent contractor is not directly the servant of the master. That means if you want to construct a house, you will engage a tapi mestri, you entrust him the work. He will get the work done through his contractors and work according to your wishes. This is the difference between an independent contractor and the servant. Independent contractor is, so if something happens, independent contractor will be held liable and not you. So this was enunciated in the famous case Govindarajulu versus Govindarajulu city, B. Govindarajulu versus MLA Govindaraja Mudaliyar. Right? This is in 1966. Actually, Govindarajulu is having a lorry. It has come for repairs. He has entrusted to mechanic shed person. Tilsini mechanic shed Richard. So that mechanic, he has repaired the vehicle, and after repair, actually he asked his boy to go for the so-called trial. Correct ఉందా లేదా ట్రయల్ చూసి రమ్మని చెప్పి పంపించాడు. కర్మగాలి వాడికి డ్యూరింగ్ ద ట్రయల్ దిస్ బాయ్ హిట్ ది ఎమ్మెల్యేస్ కార్. వాడి దరిద్రం పోయేదే మామూలు మనిషి అయితే పర్లేదు ఎమ్మెల్యే కార్ని కొట్టాడు. ఇమీడియట్లీ ది పీపుల్ స్టాప్డ్ అండ్ దే కేమ్ టు నో దట్ దిస్ వెహికల్ పలానా ఈయన బి గోవిందరాజు అని, ఆ తర్వాత ఇది మెకానిక్ షెడ్కి ఇచ్చారని. సో వాళ్ళు అక్కడ ఆపి దే ఫైల్డ్ కేస్ అగైన్స్ట్ ది ఓనర్. Here please remember, owner is he responsible or not? Here the main point. ఇక్కడ ఓనర్ గోవిందరాజులు గారు, he has entrusted the work to an independent contractor. సో ఆ మెకానిక్ షెడ్ అని ఈయన గుమస్తా కాదు, he is not servant. సో he is only independent contractor. ఆ ఇండిపెండెంట్ కాంట్రాక్ట్ చేశాడు, ఇంకొక మనిషికి అప్పచెప్పాడు. సో వాడు యాక్సిడెంట్ చేశాడు కాబట్టి దట్ ఇండిపెండెంట్ కాంట్రాక్ట్ అంటే షెడ్ ఓనర్ ఈజ్ లయబుల్ అండ్ నాట్ ది ఓనర్. ఇది ఇలా రకరకాల కేసులు ఉంటాయి. సో మాస్టర్ అండ్ సర్వెంట్ డిస్కస్ ఎట్ లెంగ్త్. I think this will be sufficient because it's getting 10 minutes time. Okay, thank you very much.